Hey, good morning, everyone. I'm Chris Parker. This is Chris Nishihara with the Ishihara and Parker Law Firm here in Longview, Texas. And today we're going to kind of talk about a common confusing issue we see a bunch. And that's basically coming down the difference between land and maybe a bank account. And Kristen, what is the common scenario that we see people asking us questions about on this?
Sure. So a lot of times folks are confused about how land or real property transfers in Texas by default. So if mom purchased a home and when she purchased her home, because she wanted it to go to you at her death, she put your name on the deed as well. Sometimes people will say, oh, well, my name is on the deed, so I'm going to get that at her death. That is not correct in Texas based on our tenants in common default. What that means is this works for married couples, this works for multiple property owners, however your name ends up on a deed with someone. Maybe you had to put your name on a mortgage for someone to be able to purchase a home, and then your name is now on the deed. But if your name is on the property in Texas, however you own that property, it passes through your estate plan at your death. It does not go to the other owner. So let's say, for example, in my hypothetical, mom bought a house, my name is on there, so we're 50-50 owners. When mom passes away, her normal estate plan, whether that's a will that gets probated, or that's she's got it in trust, or she has a ladybird deed, or she has no plan at all, and then it goes through her intestate succession, whatever mom's setup is there, that is how it will go at her death. So if I'm living with mom in the home, caregiving for her, and I own 50% of the home, that's what I still own when mom passes. But if mom has 3 kids, her 50% at her death is owned by her 3 kids. When we look at the 50-50 property, we think that when mom passes, I'm going to own it as if there's rights of survivorship on land in Texas, and there is not. We assume in Texas that your property is owned by you and should pass through your estate plan, that unless you have done something proactively to set it up, that you do not want the property to go to just the joint property owner.
Yep.
And that's really important to understand because there are other states that do it differently.
Yep. I've seen a couple situations where you have a blended family. Let's say the husband owns the home before marriage. Wife comes into the family, they get married, he wants her to feel comfortable, so he'll gift one half of his home to her. Now they each own one half as their separate property. Spouse then dies unexpectedly. Her half of the home now goes to her biological children. I've had that play out several times as an unfortunate situation. Surprised a lot of folks, especially the person who thought they owned it 100%. Like, wait a minute, I owned a home. I gave her half, she passed away, it comes back to me. And that wasn't the case. So yes, understanding property, you'll keep what you keep, but you certainly don't have any others unless the law gives it to you or they take a step. And that's where it gets complicated.
Yep. Excellent point, though. And then what comes into play there is also our community and separate property laws here in Texas. Whether it's a gift is separate property, doesn't make it community property, even though you've added your spouse's name on there. That is a very common one that we see. One other one that we see a lot is someone who has to help you get a mortgage, maybe. So if I'm purchasing land and I need an additional name on there, but they really don't have anything to do with the land, this could work both ways. This could be a child for a parent. This could be a parent for a child. But if you have participated in getting the mortgage, then you have to have an ownership interest in the property. A lot of times people don't realize that that is the result. But if my name is on the mortgage, my name will also be on the deed for the property because the bank wants to secure the note to be able to take back that property. So my name is on there. Now, there's not really anything you can do while the mortgage is outstanding except for have your estate plan in place so that if you pass away, presumably you want that property to go to the other owners, but it will not unless you have provided for that in your will. So if I'm a parent and I've helped my child co-sign essentially for a mortgage on their home that they're living in independently and they're paying the note, I don't have anything to do with it, I need to update my will to say at my death, my ownership in this property goes to this child only so that they receive that property back. If I don't do that, it will go through the rest of the terms of my will, which might be equal shares to kids. It might be something different, but I need to provide for that property.
And that will must be probated.
Right.
Very important. There's 2 steps here. The person who owns the interest, who really shouldn't, needs to have their estate plan done, probably by a will or a trust, but probably a will. And then the surviving person, the person who's supposed to own all of it, must make sure that that will is probated. Otherwise, when it comes time one day to sell it, the title company is going to raise all sorts of red flags.
Right. If the property is now paid off, you might be able to clean that up by having mom gift you her interest or doing a deed to get it out of whoever's name that it's in and it doesn't need to be in. So it might be something you can handle in another way. But either way, you need to think about that. How do I own this property? And how will it pass when I die? Who does it need to go to? Do I need to make an adjustment? Have I ownership in other properties? It's one of those things that people often forget. Like when we ask them to give a list of their property, they're not thinking about it as their property. Oh, but I did help purchase this, or I, gave my inherited grandmother's house to my daughter who lives there now. Well, it's still your property, even if you're not using it that way. Yep. So ownership needs to be correctly transferred upon your death through a correctly done plan. Yep. But don't assume that joint ownership on deeds will provide for the survivor to own that property. It will not without you taking some proactive measures. So think about how those things need to happen and make sure that your property, which is usually a very significant asset, goes to the person that you want it to go to. It's worth the time and the cost to get that done correctly now. And a lot of times that's blended families, that's spouses.
Yep. If you don't, you better have some family harmony, because eventually it's going to take a lot of work to fix it.
Yeah. Yes, you are counting on people to give interests and money back after your death if you've not done this correctly. And I would say 9 times out of 10, that is just not what's going to happen. So make sure that you do it correctly up front while you're alive and can do it. And don't be surprised by how land or real property passes in Texas, because it will go according to your plan. It will not go to another person who is named on the deed. Anything else?
Oh, that's it.
Thanks for being with us. See you next time.